So we've got several high-profile cases on the go in courts around the country today. Let's start, though, with the Senzo Meyiwa murder trial. The pre-trial conference of former eThekwini Mayor Zandile Gumede and closing arguments in the hate speech case between the EFF and lobby group AfriForum we'll get to in just a moment. And you can see that our reporters, Moloko Moloto and Desin Thathia, will bring us the latest on those. But let's start with Zandile Masikane, the Senzo Meyiwa murder trial. Drama once again as defense lawyer advocate Malisela Tefu argued against a postponement. Judge Chifiwe Maumela accusing Tefu of undermining him as the trial proceeded in the High Court in Pretoria today. And lawyer for accused number 5, advocate Zandile Mshololo, calling for the postponement to prepare her client's case after the emergence of the so-called second docket. You'll remember that proceedings were halted last week over that very issue. So our reporter Slee joins us now. So Slee, my word, this second docket, a lot has happened, and it's one of the reasons why there's a call for another adjournment. Tell us what we learned about the second docket today and why advocate for the 5th accused needs a postponement.
So interestingly enough, of course, the issue of the 375 docket is what's really threatening to derail this trial in terms of it proceeding, because advocate Zandile Mshololo says that she needs more time to be able to consult and prepare her client's defense in connection with this docket. Letters were handed in this morning by the state saying that the NPA, in particular in the South Gauteng division, the DPP there, saying that the docket has no merit and was actually an opinion by a junior advocate within the department. But advocate Mshololo is not just accepting this at face value, saying that she still wants to cross-examine witnesses in accordance to this docket, and she needs a lengthy postponement, Sally, to be able to prepare that defense. Let's take a listen.
My Lord, I ask that an order be made that the transcript for the 22nd of April be done to prove wherein my learned friend says I said I know about the existence of this docket. And above that, my Lord, knowing about the existence of the docket, it's something else. Section 87 does not say that the state has to inform the defense about the existence of the second docket. It says the state must disclose the information, including the statements contained in that docket. And that was not done by the state in this matter.
So, Slee, advocate Mshololo is really angry, you can hear there, that she didn't get access to this second docket, even though it was never signed so that it could move to an indictment stage, and the state saying, well, it's not really of any value. She, as you say, clearly wants to have a proper look at it. Advocate Tefu, who represents accused 1 to 4, clearly did have eyes on that docket. I want to understand what came out today about why that docket is even in play if it's not seen as important, and why one advocate would receive it but not another. Is it clear at all?
I think that's why we are really debating the issue around a lengthy postponement. We know that advocate Tefu has had sight of the 375 docket, so his clients are covered in terms of him knowing what's in that docket. But what advocate Mshololo is saying is that she has not had sight of this docket and requires a lengthy postponement in order to protect her client's constitutional rights for an adequate defense. But what we're seeing in terms of advocate Tefo's objections is that his clients are now also being prejudiced in terms of the possibility of a lengthy postponement in order to allow Advocate Mshololo to consult and peruse this docket. He says his clients have the right to a speedy trial and that justice delayed is justice denied. In fact, there were a number of heated exchanges between him as well as the judge because he kept on wanting to make his submissions not only around the objection to a lengthy postponement, but issues around jurisdiction once more, and the issue around the fact that this trial is being held here in the North Gauteng High Court. He believes that the process to grant this court the permission to oversee this trial, that procedure was not followed properly, even questioning the authenticity of the letter that was signed by the NDPP, Shamila Batohi, giving or sanctioning this court to hear the trial. He says, in fact, Batohi needs to come here herself and explain why she had signed that particular document. But of course, let's just take a listen, Sally, to that exchange between Judge Mamela as well as Advocate Tifo. Judge Mamela saying that Advocate Tifo is trying to bulldoze the court into basically hearing his submissions at every occasion.
My Lordship, I still feel grave as accused 1 to 4 that we are definitely being excluded from these proceedings by this court.
Okay.
Because there are very material
if you are not going
issues.
to respond to what I ask you, sit down. Sit down, Advocate Tefo. If you are not going to address dates, sit down.
I cannot be forced.
Unless you want to be in contempt of this court. I asked you a specific question. If you are not answering me on that, sit down.
Lordship, the best way, let's go to the chambers.
No, I'm not going to the chambers. About you trying to undermine me in court. I'm not going to any chambers.
But now the accused 1 to 4 has been undermined here. We cannot prolong this case.
Sit down.
Yeah.
Advocate, sit down.
You know, Slee, this is quite astonishing because normally in a court situation, the judge or the magistrate has the final say. I'm just wondering, first of all, what the reaction in the gallery is and what other legal people are saying, because could this be a situation where Advocate Tefo is skirting very close to contempt of court, or is it the sort of thing that has happened before? And then tell us what's going to happen likely tomorrow.
I think opinions are really divided in terms of the manner in which Tefo is addressing the court, the manner in which he vehemently opposes the judge when he makes a ruling. But I think it speaks to the fact that some would say he's quite passionate about this case and getting his clients off because, like the defense has been trying to show for some time now, they don't believe that there's a case against the accused and that they're being used and framed in this particular manner. But I think what we're going to see unfolding tomorrow, Sally, is the issue around the fact that the judge has asked that counsel deliberates in terms of making formal submissions because the issues that Tefo is bringing up have a material consequence for this trial. I mean, if he is alleging that this court doesn't have jurisdiction to even hear this trial, then it doesn't have the jurisdiction to actually grant a lengthy postponement. So what the judge is saying is that he needs formal applications, heads of arguments to be filed. Tomorrow we will hear in terms of the role planners for the court when those arguments can be heard in terms of the issues that were raised by Tefo on jurisdiction and on the authenticity of the NPA's letter granting this court that jurisdiction. And then we'll also hear, of course, when exactly the trial will resume officially. There are dates being discussed in September, in November, as well as a block end date sometime next year for about 3 months at the beginning of the year, Sally.
My word. And of course, it's important to note that currently the trial is in Pretoria, which is where you are, but if this jurisdiction issue is not sorted out, we may well see it move to Johannesburg. So it'll be very interesting to see what happens tomorrow. Steve, thank you very much. Let's move now to another very important trial, and that is the corruption trial of former eThekwini Mayor Zandile Gumede and her co-accused. That is set to start next month. Only 2 of the accused were actually in court today for the pre-trial conference. It was decided following arguments in court that the case will be heard in Durban and not in Pietermaritzburg. eNCA senior reporter Dessen Thathia was in court and he brings us the latest now. Hello, Dessen. So talk to us about this pre-trial hearing. What came out? Why the decision to move it from Pietermaritzburg to Durban?
Well, this was a very necessary part of getting to the trial cell, so we'll have to wait just a little bit longer to get into some of those details, which are expected to come out during the trial. You would know from that indictment, which is almost 400 pages, that it reads like a crime thriller. I mean, you have a former mayor, you have a former city manager, you've got senior ANC officials, you've got contractors, all of these players allegedly using the eThekwini municipality for their own benefit, to draw benefit from the funds that are meant to go to services. And in this case, the 320 million rand that was allocated to waste collection tenders. And at the forefront of all of this was allegedly Zandile Gumede, who had gained about 2.8 million rand in benefits, in monetary benefits and in other forms of kickbacks. So all of that very interesting. The state will have a lot to prove in that sense. But before we get into that trial, as I mentioned, they had to iron out the very necessary items that come before a trial. So at this point, it seems like they are ready to proceed. Initially, the matter was meant to be in Pietermaritzburg, like you mentioned, but that was because of a space issue. So fortunately, with the defense team now having a consensus that they wanted the case to be closer, they wanted it to be in Durban because that's where all of the accused come from. The judge ultimately agreed for that to happen. But there were a few other issues as well. Some of the defense lawyers saying that they have not received payment for their services. One of those, Advocate Carl van der Merwe, saying that his clients, accused 15, 16 and 17, had about 9 million rand that was frozen, and he wanted to bring an application to have some of that money released to pay for his fees. Otherwise, he wouldn't be able to proceed. But let's listen into a snippet of what Advocate Jimmy House had to say during the arguments at the pre-trial conference.
But Milady, there is a bigger problem, and perhaps I can mention that first. There is a very lengthy forensic audit report in this matter, and it forms the foundation of the state case. Milady, our reading of that report, and I think my colleagues will share this view, is that it's virtually incomprehensible because of extensive redacting of names and information in that report. So, Milady, that is making it very, very difficult, if not impossible, to prepare.
So does that, I mean, that sounds like quite a big stumbling block, but we're hearing the trial's going to go ahead next month. Talk to us about whether it really will go ahead next month.
Well, it's looking good at this stage, Sal. So effectively it means between now and that date of the 18th of July, the defense and the state have time to iron out those issues. You would have heard the Advocate Jimmy House talking about the issue with that forensic report and how in some cases it's not easy to read because of those redactions. So that'll be amended or dealt with between now and then. There were dates that were given out by the judge, but all of this to ensure that things do get underway on the 18th of July. Let's listen in to what the judge had to say about the way forward now as we move towards the trial next month.
By Friday, the 17th, the state will let all the parties know whether it consents to the rebuttal of the names in the report.
Yes.
And then whatever response, if there are any applications to be brought, they must be filed and sent by the 27th.
All right, so it's all going to kick off on the 18th of July. And of course, that's Nelson Mandela's birthday. So it's quite a fortuitous date indeed, and happening in Durban. Thank you very much, Dessen Thathia. Now, the High Court in Johannesburg today heard closing arguments from the EFF and AfriForum in the hate speech case. The lobby group lodged a complaint in 2020 over the EFF singing "Kill the Boer," that's a struggle song, outside a Free State court. That was during the appearance of a man accused of killing farm manager Brendan Horner. You may remember that case. eNCA's Moloko Moloto is following the story. He joins us now. Hello, Moloko. So today we heard closing arguments from the EFF and AfriForum. Talk to us about what they both said.
Hello, Sally Badet. Indeed, just a short while ago, the judge, this is Judge Edwin Molatlehi, who is the presiding officer in this civil case involving lobby group AfriForum. They have taken the EFF and the party leader Julius Malema to court, as you correctly said, over their continued singing of that infamous song, "Kill the Boer, Kill the Farmer." But Judge Molatlehi said that he is going to, the parties here will have to wait at least for him to deliver judgments for cases that he has had to preside over on urgent basis in the past 2 to 3 weeks. So we'll have to wait and see when judgment in as far as this matter is concerned will be handed down. But importantly, what transpired today, Sally, just to remind our viewers, is that AfriForum is essentially seeking a declaratory order over the fact that there's continued singing of this particular song. But it's worth mentioning that Mr. Malema himself, you'd remember that since the Equality Court judge ruled against the singing of this song when Malema was still the suspended leader of the ANC Youth League. Ever since then, Mr. Malema has really never sung this controversial song. What he's been doing instead was that he replaced the "Kill the Boer" song, "Kill the Boer" lyrics with "Kiss the Boer." Now, it appears AfriForum is not happy with that still. Of course, we continue to see today, for instance, here in court, AfriForum played a video of people wearing EFF colors, also brandishing the flag, and those were just ordinary people who were singing "Kill the Poor, Kill the Farmer." So AfriForum is arguing that Mr. Malema, basically because he's an influential party, political party leader, he needs to be told that this remarks or this song is hurtful, it is discriminatory, and he is basically encouraging people to go on and kill, particularly the Afrikaners and the people who are known as Boers, to an extent that AfriForum is saying that the killing of farmers in this country is directly related to the singing of this particular song. So today we first had the lawyer representing AfriForum, Advocate Mark Oppenheimer, indicating that basically the court needs to make it clear that as much as previously in 2011 the Equality Court had ruled that the singing of this song is hate speech, this particular court needs to put the foot down and make a declaratory order. Also go on to order Mr. Malema to pay at least R500,000, which will be deposited or be given to an organization that is fighting hate speech, and also make Malema and the EFF apologize publicly. Let's listen to Advocate Oppenheimer here.
Now, Mr. Malema took the oath, testified, and I submit that there is reason to investigate his conduct, and I'll deal with the particular evidence that he gave later. But in brief, he was asked whether he and the EFF would be able to make payment of the R500,000 that is sought by the complainants to the organisation that combats racial hatred, and he stated, "I have nothing and the EFF has nothing." Now, the EFF is an organisation that is compelled to disclose its donations in terms of the electoral legislation, and has disclosed that it received a donation very recently in the sum of R3 million. And Mr. Malema is on record as saying that it's well known that he wears famous brands like Gucci. So I submit there is good reason on the face of it to investigate that it's a very serious matter when an opposition politician would perjure himself in court, and there appears to be a basis for such investigation. But again, that would be done by the DPP.
There's AfriForum's lawyer questioning whether the EFF really doesn't have the money to pay. Let's listen now to the EFF lawyer, Advocate Mfesana, and he, of course, throwing some shade at AfriForum's Ernst Roos. Take a listen.
We could have dealt with this by merely calling them and asking them to testify about the contradiction, but the problems with that should be quite evident, Your Lordship. All we're simply saying is make a ruling on this, Your Lordship, when you apply your mind. What is the probability that my learned friend would stand here, implicate his attorney, stand by a version, knowing very well that Mr. Rhodes is going to come and testify later, but yet put a flag on a mast that is not an instruction of client, knowing very well the client is going to come and testify? I would suggest, Your Lordship, reasonably, it must be that he took that instruction from Mr. Rhodes. He's got an ethical obligation to act on instruction. We must assume he did. That again speaks to the credibility of Mr. Rhodes, the chopping and the changing of versions at convenience.
All right, so that's where we'll leave it. Closing arguments in that case. Thank you so much for that update. eNCA reporter Moloko Moloto in Johannesburg, Dessen Thathia in Durban, and Zandile Masekane in Pretoria. Thanks to all of you.